Let me know once we are live. Hello and welcome to BYJU'S Exam Prep. Today is Lecture 3 of Polity-Based Current Affairs, Targeting Prelims 2022. We have had 2 sessions on Indian polity. We'll have the 3rd session today and tomorrow, the last session on Indian polity. But the Target Prelims 2022 shall continue till May 21. So let's get started and look at question number 1. But before that, why don't you press the like button? Comment once the video is over, subscribe to our channel if you haven't yet, and share the links of these classes with your friends and fellow aspirants. Let's look at question number 1. The Special Officer for Linguistic Minorities is an extra constitutional post. Statement number 2, the National Education Policy proposes an early implementation of the 3-language formula to promote multilingualism from the school level. In the last session on Sunday, we looked at some of the questions related to the languages because Hindi, whether it is a national language or not, there was some controversy. In fact, on national education policy, there is a meeting underway which is headed by the Prime Minister of this country, Mr. Modi, right now. So this topic becomes very, very relevant for Prelims 2022. What is a constitutional post? Any post which is mentioned in the Constitution is a constitutional post, is a constitutional body. For example, UPSC is a constitutional body. State Public Service Commission is a constitutional body. Finance Commission is a constitutional body. CAG is a constitutional body. Election Commission of India is a constitutional body. But there are other bodies or other posts which are not mentioned in the Constitution but created by a parliamentary law. Those are what we call statutory bodies or extra constitutional bodies. But there are also some bodies which are neither constitutional nor statutory, neither mentioned in the Constitution nor created by a parliamentary law. And those are what we call extra constitutional non-statutory bodies which are created by a government resolution. For example, Niti Aayog is created like that. Prior to Niti Aayog, we had the Planning Commission, which was created like that. National Development Council was created like that. But the Special Officer for Linguistic Minorities, it is basically not an extra constitutional post. In fact, it is a constitutional post. It is mentioned under Article 350, capital B of the Constitution. But look at the other context. The year was 1956 when the states were reorganized in this country. States Reorganization Act was passed in the year 1956, which created 14 states and 6 union territories. But that States Reorganization Commission, what it basically did, it prescribed that language can be the basis for reorganization. If we have to reorganize the country into various states and union territories, for that language can be an important ground on the basis of which the states can be created. Because prior to the States Reorganization Commission, various committees, various commissions were set up. For example, Dar Commission. For example, JVP Committee. JVP Committee, which consisted of Jawaharlal Nehru, Sardar Vallabhbhai Patel, Patabi Sitaramaya. Both these committees were asked to suggest how do we and how should we reorganize the country. And both of them rejected language as a criteria to reorganize the country, to create more and more states. But it was the States Reorganization Commission which recommended that no, language can be the basis for reorganization of this country. But the States Reorganization Commission, a very important fact, it rejected one language, one state formula. Now, what is the difference? The difference is, yes, can we create states on the grounds of language? Can language or linguistic criteria be one of the criteria for reorganizing the states? Yes. But we will not have one language as one state criteria, which means within this recommendation, the focus was on administrative convenience. The state should not be too huge, too large, so that it becomes difficult to administer and govern these states. Otherwise, if one language, one state formula was accepted, then possibly the entire North India could have been one state, because almost the entire North India speaks one language, which is Hindi. So yes, Hindi can be the basis for reorganization. Telugu can be the basis for reorganization. Tamil can be the basis for reorganization. But one language, one state, no. We still have to create states on the basis of administrative convenience. And why are we discussing this? Because this Article 350 capital B, it was not originally part of the Constitution. It was added by the Constitution by 7th Constitutional Amendment Act. The year was 1956, based on the recommendation of the States Reorganization Commission. Because the States Reorganization Commission accepted that language can be the basis for reorganization of this country. We have other directives as well. For example, we have Article 350 capital A. What does Article 350 capital A speak about? It talks about linguistic minorities. If I am a child belonging to a linguistic minority, let's say I come from Maharashtra, but I'm residing in Tamil Nadu, there is an obligation on the state of Tamil Nadu that every local authority, every state authority in Tamil Nadu will have to provide me education in my own mother tongue, which is Marathi, till the primary stage of education, till the 5th standard. That is an obligation under Article 350 capital A. So long story short, 350A tells us that if you are a child belonging to a linguistic minority, but you're residing somewhere else, in that state, every local authority, every state authority has an obligation that you have to provide these children of linguistic minorities education, instruction in their own mother tongue, at least till the primary stage. What if the state does not follow this directive? In that case, a notification, in that case, a directive can be issued by the central government under Article 365. And if the state government, any state government, if it fails to abide by this directive issued by the center, then it can be construed that there is a breakdown of constitutional machinery in that state, and President's rule under Article 356 can be imposed. What is the question? This Special Officer for Linguistic Minorities is an extra constitutional post. This is wrong because it's a constitutional post. The National Education Policy, it proposes an early implementation of the 3-language formula to promote multilingualism from school level. This statement is correct. Which of the above statements is or are correct? B. Only 2 is the right answer. Now, what is the backdrop of this 3-language formula, which is under criticism from various southern states in India? We discussed in the last class that Hindi is not the national language of India. Hindi is the official language of this country, of the Union, according to the Constitution. But the same Constitution said that we can continue to use English for 15 years from the commencement of the Constitution. That means from 1950 till 1965. And after 1965, Hindi alone will be the official language of the Union. This is where the southern states protested, particularly the then state of Madras, which is today's Tamil Nadu. There was an anti-Hindi agitation in which scores of people also got killed. And the compromise was, in the form of a law passed by the Parliament called Official Languages Act of 1963. And it is this Official Languages Act which says that we can have English as well as Hindi as the official language of the Union. And also later on, a 3-language formula was created. According to this formula, if you are in North India and if you are in South India, for example, if you are in South India, 3 languages will be taught to the students at the school level. One will be the local language, the other will be the English, and the third one would be Hindi. And in North India, 3 languages will be taught to the students. One is Hindi, the other is English, and then the third can be any Indian language, preferably a South Indian language, so that these beautiful South Indian languages can be promoted and popularized in the northern India, and Hindi can also be promoted in the southern Indian states, because it is the obligation on the Union under Article 351 that you have to promote Hindi so that Hindi language becomes a medium of instruction for all the elements of the composite culture. So this 3-language formula is now again in the news because the new national education policy, it wants to implement this 3-language formula at the school level so that we promote multilingualism. Multiple languages should be understood and taught to the students. Let's look at another question. National emergency. And we are discussing this because there is emergency imposed in Sri Lanka. So if there is emergency imposed in Sri Lanka, there can be a question asked by the UPSC on some of the emergency provisions that we have under the Indian Constitution. And which are these emergency provisions? We have some difficult questions on emergency. One is Article 352, which deals with national emergency. Then we have Article 356, which deals with President's rule. Then we have Article 360, which deals with financial emergency. What is this national emergency? If the President is satisfied because of war, because of external aggression, because of armed rebellion, and remember, armed rebellion as one of the grounds for the imposition of national emergency, it was not originally part of the Constitution. It was added to the Constitution by 44th Constitutional Amendment Act 1978. Because the year was 1975 when national emergency is alleged to have been misused, overused and abused in India. When the then Prime Minister, Shrimati Indira Gandhi, asked the President to impose national emergency on the grounds of internal disturbance. But this internal disturbance is a very vague phrase. It is liable to be misunderstood, misinterpreted, misused. That is why, to curb the misuse of Article 352, the year was 1978 when Constitution was amended, replacing internal disturbance with armed rebellion. So now national emergency can be proclaimed by the President on the grounds of war or external aggression or armed rebellion. That too on the written advice of the Cabinet. Because in 1975, when emergency was imposed, it was imposed, proclaimed by the President on the basis of the oral advice of the Prime Minister. Now in 1978, Constitution was amended, specifically inserting the word Cabinet, which was inserted into the Constitution for the first time. So now the word Cabinet was introduced, and now President can proclaim national emergency not on the basis of the oral advice of the Prime Minister, but on the written advice of the Cabinet. This is how national emergency can be proclaimed. And national emergency, once it is proclaimed, within 1 month of its proclamation, both Lok Sabha as well as Rajya Sabha, they have to approve national emergency, that too by special majority. And when both houses of the parliament separately approve national emergency by passing a resolution by special majority, this national emergency continues for 6 months. Can it be extended further? For another 6 months. Can it be extended further? For another 6 months. Can it be extended further? Yes, there is no upper limit. National emergency can be imposed for any number of years, any number of times, but 6 months at a time. After 6 months, you have to seek the approval of the parliament again. And this 6-month approval also was not originally part of the constitution. It was added to the constitution by 44th Constitutional Amendment Act 1978. This is where questions have been framed by the UPSC. For example, the question framed was, which of the following directive principles were introduced into the constitution because of 42nd Amendment or 39th Amendment? So you have to be clear as to which changes were made by different constitutional amendment acts. One change in 1978 was, on the written advice of the cabinet, national emergency can be imposed. That too can be imposed on the grounds of war, external aggression or armed rebellion, and at the same time, every 6 months, you have to again go back to the parliament, seek the approval of the parliament, and further give approval. This is what we call national emergency. Let's look at the questions. National emergency cannot be proclaimed by the president before the actual war, external aggression, or armed rebellion. This statement is wrong, because the president can proclaim national emergency even before the actual war has broken out, even before external aggression, even before armed rebellion has broken out. So it means even before the actual occurrence of war, the president, if he is satisfied that there is a grave danger to the unity, integrity of India because of war, because of external aggression, because of armed rebellion, then president, on the written advice of the cabinet, can proclaim national emergency even before the actual occurrence. Statement 2. Under special circumstances, Parliament can pass a resolution for the imposition of national emergency. National emergency can be proclaimed by the president on the written advice of the cabinet. There is no concept, no provision in the constitution which empowers the parliament to pass a resolution empowering the president to proclaim national emergency. No, this statement also is wrong. There is no special circumstance mentioned in the constitution. Third, every proclamation, including a proclamation revoking national emergency, shall have to be laid before each house of the parliament. I told you, when national emergency is proclaimed, then within 1 month of its proclamation, both Lok Sabha as well as Rajya Sabha will have to approve this national emergency by passing a resolution by special majority. Then if we want to extend it further, again seek the approval of the parliament. But if the president, and remember this carefully, if the president wants to revoke national emergency, he can do that only on the advice of the cabinet, and when he is revoking national emergency, there is no need to place this revocation on the floor of the parliament. So this statement 3 is also wrong. Every proclamation, including the proclamation revoking national emergency, shall have to be laid before each house of the parliament. This is wrong. If the word was excluding, then the statement would have been correct. The question is asking which of the above statements is or are correct. None of these statements are correct. D is the right answer. Let's look at another question. National emergency, there is no special power vested in Lok Sabha, as both houses of the parliament have an equal role. Both houses of the parliament have an equal role in a sense that both houses of the parliament will have to separately pass a resolution approving national emergency by special majority. If Lok Sabha passes this resolution, Rajya Sabha does not, national emergency will have to be revoked. If Rajya Sabha passes this resolution, Lok Sabha does not, national emergency has to be revoked. But the year was 1978, when 44th Constitutional Amendment Act was passed. another article was added to the Constitution. Another clause was added called Article 352, Clause 8. You don't have to remember these article numbers, just understand the concept. And the concept is there is a special power given to Lok Sabha. Lok Sabha is given a special power. And what is that special power? If 1/10 of the members of Lok Sabha, 1/10 of the members of parliament belonging to Lok Sabha, if they write to the speaker or if they write to the president, when can Lok Sabha MPs write to the speaker? If Lok Sabha is in session. If Lok Sabha is in session, 1/10 of the MPs of Lok Sabha will have to write to the speaker. If Lok Sabha is not in session, then 1/10 of the MPs of Lok Sabha will have to write to the president. And what is this writing for? That please convene a special sitting of Lok Sabha so that we can not continue with national emergency. So a special power is given to Lok Sabha. This special power is not given to Rajya Sabha. Under Article 352, Clause 8, 1/10 of the members of Lok Sabha can write to the speaker if Lok Sabha is in session, can write to the president if Lok Sabha is not in session, requesting for a special sitting of Lok Sabha to discuss this national emergency. And in this special sitting, very important point, if a resolution is passed by Lok Sabha by simple majority, then it becomes binding on the President of India that what President has to do, he has to revoke national emergency. So there is a special power given to Lok Sabha under the Constitution of India, wherein it can convene or request for a special sitting and disapprove the continuation of national emergency. So the statement in national emergency, there is no special power vested in the Lok Sabha as both houses of the parliament have an equal role. This statement is wrong. Statement number 2. If emergency is imposed in one state, the executive power of the union is restricted to that state only. This statement is also wrong. Which of the above statements are correct? D. None of the above is the right answer. In national emergency, once it is imposed, our constitution, which is normally federal, changes its form and becomes a unitary constitution. And in this unitary setup, the executive power of the center extends to states as well. I don't have to explain what is this executive power because this is just a revision. You would understand the concept. In fact, Parliament during national emergency can make law on state list as well. Under Article 250 of the Constitution, whenever there is national emergency, Parliament assumes concurrent power of legislation. It can make a law on any item mentioned in the state list as well. And this law, which is passed by the Parliament during national emergency, it continues till national emergency continues in India. And the moment national emergency is revoked, this law passed by the Parliament on state list continues for a further period of 6 months. After that, it is automatically lapsed. Which means this, that even the executive power of the union can extend to any other state, even if in that state emergency is not imposed. Because national emergency can be either imposed in the entire country or in any state or any part of that state. If national emergency is imposed in Rajasthan, the executive power of the union can extend not only to Rajasthan but can extend to Gujarat as well, any other state as well. That is why this statement is wrong. Which of the above statements are correct? D. None of these statements are correct. D is the right answer. Let's look at something else. There is a duty on the union that you have to promote Hindi so that Hindi can become medium of instruction for all the elements of the composite culture. There is another duty on the union, and this duty is imposed under Article 355 of the Constitution. What is this duty? There is a duty on the state that you have to protect the state from external aggression as well, from internal disturbance as well. It's a duty on the center, on the union, that you have to protect the state from external aggression, from internal disturbance as well. And at the same time, there shall be a duty on the union to ensure that governance in every state is carried out according to the provisions of the Constitution. It shall be the duty of the union to protect a state from external aggression, from internal disturbance as well, and at the same time there is additional duty under Article 355 on the center that you have to ensure that governance in every state is carried out according to the provisions of the Constitution. And whenever in a state governance is not carried out according to the provisions of the Constitution, then that state government can be dismissed. A president's rule can be imposed in that state under Article 356. So what is the answer to this question? C. Both A and B is the right answer. Let's look at another question regarding the president's rule. Under Article 356 of the Constitution, the president has a power. What is the power of the president? If the president is satisfied on the report of the governor or even otherwise, this phrase becomes very important. Why? Some controversy. What is the controversy? There was a petition filed in Andhra Pradesh High Court, and basis that petition, the High Court of Andhra Pradesh decided to conduct an inquiry to see if there is a sufficient case under which we can recommend to the president that there is a breakdown of constitutional machinery in Andhra Pradesh so that we can have president's rule in Andhra Pradesh. This order of Andhra Pradesh High Court was withdrawn by the Supreme Court, luckily. But on what basis can a High Court advise the president that you have to impose president's rule in a state? Where is this provision? This provision can be traced to Article 356 of the Constitution. What is Article 356? If the president is satisfied, based on the report of the governor or even otherwise, that means there can be a different report. Maybe the report from a high court, maybe the report from intelligence, maybe the report from external intelligence. If the president is satisfied, based on the report of the governor or even otherwise, that there is a breakdown of constitutional machinery in a state, then what the president can do? He can impose president's rule in that state. And when president's rule is imposed in a state, then the federal relationship takes a hit, and for that particular state, the relationship is that of a unitary character. It's as if for that state and the Union of India, there is a unitary relationship, not a federal relationship. The president cannot impose president's rule on his own. He has to impose only on the advice of the cabinet, only on the advice of the central government, because president does not have any discretionary power of his own. There is only one discretionary power available with the president. And can you tell me what is that discretionary power? Appointment of the Prime Minister. We've structured these lectures in such a manner that even in these short lectures of 2 hours, we are covering almost the bulk of the static portion as well. Constitution says the Prime Minister shall be appointed by the President. That's it. It doesn't say who is this Prime Minister going to be. So in appointing a Prime Minister, the President has a discretion. This is the only discretionary power available with the President. But once the Prime Minister is appointed, and on the advice of the Prime Minister, other members of the Council of Ministers are appointed, then their advice becomes binding on the President. That's what Article 74 says. Article 74, there shall be Council of Ministers with Prime Minister at its head to aid and advise the President, who shall act on that advice, provided the President may ask for reconsideration of that advice, but once the same advice is given again, it becomes binding on the President. So there is no discretionary power available with the President, except appointment of the Prime Minister. And this President's rule, once it is imposed in a particular state, it continues for 6 months, can be extended for another 6 months, can be extended beyond 1 year for another 2 years. But each time it can be only for 6 months at a time. This is something that you would have read. The point is, this President's rule, once it is imposed, both houses of the Parliament, Lok Sabha as well as Rajya Sabha, they have to approve this President's rule by passing a resolution by simple majority. So approval of national emergency by the Parliament requires special majority. But the approval of President's rule in a state requires simple majority. And this approval should be given by both houses of the Parliament within 2 months. Within 2 months of the imposition of President's rule, both Lok Sabha as well as Rajya Sabha, they have to approve President's rule by simple majority. And once it is approved, President's rule continues for 6 months. Then for another 6 months. Can it be extended further? For another 2 years, but 6 months at a time. But this 2-year approval is based on some conditions. Which are these conditions? National emergency can be imposed in that state or any part of that state. An Election Commission of India should certify that under the current situation, it is not possible to hold and organize elections. If these two conditions are met, and only if these two conditions are met, then President's rule can continue beyond a period of 1 year. Otherwise, President's rule can continue only for 1 year. Can be extended for another 2 years, provided these conditions are met, which means the maximum constitutional validity of President's rule is 3 years. And beyond 3 years, you cannot extend the President's rule in a state. Let's look at the question. The question is, the report of the governor is prerequisite for the imposition of President's rule in a state? No, although the report of the governor is important. But even without the report of the governor, this is where Mr. Karunanidhi's government was dismissed in early 1990s by the central government, even without a governor's report. So governor's report is not a prerequisite. Even without his report, President's rule can be imposed in a state. So this statement is wrong. According to the Constitution, the President can assume all functions of the state, government and legislature to himself. This is where some of you may find this statement confusing. There is something called President's Proclamation. When the President imposes President's rule, he proclaims that all the powers of the state government will be assumed by the President, except he cannot assume the powers of the legislature. He cannot assume the powers of the High Court. In his proclamation, the President may say that the power of the legislature, state legislature, shall be vested with the Parliament or an authority authorized by the Parliament. So President can assume all the executive powers to himself when President's rule is imposed, but he cannot assume the powers of the legislature of that state, because the powers of the legislature shall be exercised by the Parliament. So Parliament can make laws for that state, or Parliament may give this responsibility to some other authority. But governor cannot assume the powers of the legislature to himself. So this statement also is incorrect. And this case when the president's rule is imposed in a state where parliament becomes the legislature for that state, the law passed by the parliament during president's rule, important statement, it continues even after the revocation of president's rule. Even after that. But the law which is passed by the parliament during national emergency continues only till the national emergency is imposed in this country and can continue for a maximum period of 6 months after the revocation of national emergency. But that is not the case when it comes to president's rule. When president's rule is imposed in a state and the law on state list is passed by the parliament, this law continues even after the president's rule is revoked. So the life and death of this law passed by the parliament during president's rule does not depend upon the life of the president's rule. It continues beyond that as well. Of course, state legislature can later on revoke that law passed by the parliament. Clear? Third is, a law passed by the parliament during the president's rule shall cease to operate after the revocation of president's rule. This statement is wrong because this law passed by the parliament during president's rule continues even after the revocation of president's rule. The question is asking which of the following statements regarding president's rule is or are correct. None of these statements are correct. D is the right answer. Let's look at another question, and this is slightly tricky, but let's see how many amongst you would get this right. When we say and use this expression, proclamation of emergency, what does this expression, proclamation of emergency, mean? Does it mean only the proclamation under Article 352? Or also the proclamation under Article 356? Or also the proclamation under Article 360 of the Constitution? What is Article 360? It deals with financial emergency. If the president is satisfied that there is a grave threat, danger to the financial system, to the credit of the nation, then the president can impose financial emergency. This financial emergency, once it is imposed by the president, within 2 months, it is to be approved by both houses of the parliament, Lok Sabha as well as Rajya Sabha, that too by simple majority. There is a crisis in Sri Lanka because of the financial mismanagement or the alleged financial mismanagement. So financial emergency can be asked in your examination. Under Article 360, if the president is satisfied that there is a grave danger or threat to the credit, to the financial stability of the nation or the territory of India, then the president can impose financial emergency. And once the president, on the advice of the central government, imposes financial emergency, this financial emergency shall have to be approved by both houses of the parliament within 2 months, that too by simple majority. And if it is approved by both houses of the parliament by simple majority, this financial emergency continues unless revoked by the president. What's the difference? National emergency, once it is imposed, it continues for 6 months. Can be extended for another 6 months, then another 6 months. And this is what we call periodic parliamentary control. After every period of 6 months, Parliament will exercise the control over national emergency, whether it should continue or not. For President's rule, the maximum limit is 3 years. But there is no upper limit for financial emergency. Once it is imposed by the President, approved by both houses of the Parliament separately, by passing a resolution by simple majority within 2 months of its imposition, then financial emergency continues unless and until it is revoked by the President. So when we say this phrase, proclamation of emergency, which type of emergency are we talking about? Are we talking about only 352 or only 356 or only 352 and 356 or all the 3 types of emergencies under Article 352, 356 and 360? How do I get to know the answer to this question? Let's say there are 1.6 thousand people watching. Those who say that it includes only a proclamation issued under Article 352, please press the like button. This expression, Proclamation of Emergency, means only a proclamation issued under Article 352. This phrase does not include 356, does not include 360. Technically, emergency or the Proclamation of Emergency is used only for Article 352 of the Constitution. Please get that straight. Let's look at another question. According to the Constitution, and this is another area of controversy between the governor of Kerala and the state government, the governor of Tamil Nadu and the state government, governor of West Bengal and Didi. So there is a lot of tussle going on between the appointed governors and the elected chief ministers. The controversy is also on the appointment of the vice chancellors in universities. Because normally in the states, wherever we have the state universities, the governor is also the chancellor of these universities. And now there are some states such as Tamil Nadu, such as Kerala, they want to deprive governor of his responsibility as the chancellor of the state universities. And it is in this backdrop that we are having some of the questions on the office of the governor. Very important, some difficult, some tricky questions, but these questions can be very, very important, very, very relevant for your prelims 2022. Question, statement number 1. According to the Constitution, the governor of a state is the chancellor of the state universities. This is not mentioned in the Constitution. The governor is the chancellor of state universities because the state legislatures have passed laws based on which the governor becomes the chancellor of the state universities. It is not mentioned in the Constitution. In fact, something else related to this. We have had various commissions on center-state relations. For example, Sarkaria Commission. For example, Punchi Commission of 2005. It was the Punchi Commission which was headed by former Judge M.M. Punchi. This can be an important statement for your prelims examination. Punchi Commission had recommended that this practice or this convention that governor of a state is the chancellor of the state universities, this convention should be done away with, this provision should be done away with. Governor should not play the role of the chancellor of the state universities. This was something recommended by M.M. Punchi Commission. So according to the Constitution, the governor of a state is the chancellor of the state universities. This statement is incorrect. The Constitution allows the appointment of the same person as governor for up to 2 states. Is the statement correct or incorrect? Till the year 1956, we had one governor for one state. The year was 1956, when 7th Constitutional Amendment Act was passed in the year 1956, because it was in the year 1956 that the states were reorganized in this country. And it is this Constitutional Amendment Act of 1956 which allows that the same person can be appointed as the governor of more than one state. We saw in the recent past, in the last couple of years, we saw the same governor was appointed to Uttar Pradesh and Madhya Pradesh as well. That is the context of what this question is all about, what the statement is all about. So this statement, Constitution allows the appointment of the same person as the governor for up to 2 states. This is wrong. Constitution allows the appointment of the same person as governor for more than one state. It can be more than 2 states as well. It can be more than 3 states as well. The question is asking which of the above statements is or are correct. D. None of these statements are correct. D is the right answer. Let's look at another question. According to the Constitution, a governor shall hold office for a term of 5 years from the date on which he enters upon his office. Constitution talks about the governor, that governor is the executive head of a state. And this governor is a constitutional link between the center and the state. The governor is not the agent of the center. The governor is the constitutional link, is the representative of the center in a particular state. And almost all the provisions relating to the office of governor can be traced to the Government of India Act 1935. So in fact, we have copied the provisions that were mentioned for the office of governor in the Government of India Act 1935. Same provisions have been copied in the Constitution of India as well. In fact, during Constituent Assembly debates, there was a lot of debate, lots of controversies on continuing with this office of governor. Some said, no, we should not have the office of governor because we know what the governor is capable of doing. And we saw how the governor was blocking all the legislative agenda in the pre-constitutional India, in the colonial period. But then this office of governor was continued because of two reasons. Reason number one, Constituent Assembly said that there is a dearth of competent legislators in India. That is why we need the office of governor. And at the same time, Constituent Assembly continued with the office of the governor on the grounds that a certain element of centralization is necessary, because we have just come out of partition and we want to keep the country united, and we need a central figure in a state who can keep the state within the Union of India. So some element of centralization of power is necessary. But governors have been creating lots of controversies as well. That is why there are some individuals, some experts, some states which say the office of governor should be abolished as well. Whether it should be abolished or not, that's the subject matter of our mains examination. But for the prelims, Constitution only talks about that governor shall be appointed by the president. And the governor normally holds the office for 5 years, which is mentioned in the Constitution. But the governor holds office during the pleasure of the president. This is what we know as the doctrine of pleasure, which means the governor continues to remain in office as long as he enjoys the pleasure, the confidence of the president, which effectively means as long as he enjoys the pleasure and the confidence of the central government, because it's the central government which is basically advising the president as to who should be the governor of a particular state. And there are two qualifications mentioned in the Constitution, just two. Who is this governor going to be? This person shall be the citizen of India and must have completed 35 years of age. These are the only two qualifications mentioned in the Constitution. Who is a governor of a state? The governor is appointed by the president. Who is qualified to be appointed as the governor? Somebody who is the citizen of India and somebody who has completed 35 years of age. That's it. But additionally, two conventions have resulted. Two conventions. Conventions are unwritten rules. And which are these unwritten rules? That while appointing governor to a state, this governor should not be the resident of that state. Should be a non-resident. If a governor to Karnataka is to be appointed, he should not be the resident of Karnataka. If a governor to Madhya Pradesh is to be appointed, he should not be the resident of Madhya Pradesh. So the governor should be a non-resident. And another convention, whenever the governor of a state is to be appointed, the chief minister shall be consulted. But please remember, these are only conventions, unwritten rules. These rules are not mentioned in the Constitution. That is why these conventions have been violated as well. Constitution only talks about two qualifications, and these are not the qualifications mentioned in the Constitution. Qualification is, if you are a citizen of India and you have completed 35 years of age, then you are qualified to be appointed as the governor of a state by the president. Your term will be 5 years, But even before 5 years, you can be removed. This is where the doctrine of pleasure comes into picture, which means the governor does not have security of tenure. There is no security of tenure. And in fact, there is no such provision as that of impeachment. President is to be elected. We are going to have presidential elections, vice president elections this year. So we will have some of the questions on presidential election, vice presidential election as well. Either today or tomorrow we will discuss these questions. But president, once he is appointed, he can be removed from his office as well, because normally the term is 5 years. But even before 5 years, the president can be removed. But the president is removed through a very complicated process called impeachment, where the president is removed on the grounds of violation of the Constitution, where the president is impeached based on the resolution passed by both houses of the parliament, that too by one of the toughest majorities mentioned in the Constitution, not less than 2/3 of the total strength of the house. So the ground of removal is mentioned, the process of removal is mentioned, but that is not the same as that of a governor. The governor is appointed by the president, can be removed by the president. There is no impeachment required, and there are no grounds mentioned in the Constitution as well. But something significant, which has been quoted by lots of newspapers in the recent past in the backdrop of the controversy regarding the governors. Beautiful judgment of 2010, BP Singhal, where the Supreme Court has said that governor is the constitutional head of a state. The governor is a constitutional link between the center and the state. And the Supreme Court has said that you cannot be removing governor in an arbitrary manner. Just because there has been a change in the government at the central level. This change in government at the central level does not mean that you can change the governor in the states as well. There has to be solid reason, and that too in written. There has to be a written reason as to what led to the removal of a particular governor. This is something which BP Singhal versus Union of India Supreme Court said, and this judgment has been quoted numerous times in the recent past. So what is the question? According to the Constitution, a governor shall hold office for a term of 5 years from the date on which he enters upon his office. This is correct. Can a legislator also be appointed as the governor of a state? Yes. And once an individual legislator is appointed as the governor of a state, and if today I'm a legislator, I'm appointed as the governor of Karnataka or Tamil Nadu, if I'm appointed as the governor of Tamil Nadu, from the date I entered my office, it shall be deemed that I have resigned, vacated my seat in the legislature. So if a legislator is appointed as a governor, he shall be deemed to have vacated his seat on the date on which he enters upon his office. This statement is also correct. So which of the above statements is or are correct? C. Both. B is the right answer. Both C, A, both 1 and 2, C is the right answer. Let's look at another question. And this is where some of the bills passed by the Legislative Assembly, they have not been decided upon, signed by the governor. And this is the controversy in Tamil Nadu. This is the controversy that we have seen in other states as well. A money bill passed by the Legislative Assembly cannot be returned by the Legislative Council. Is the statement correct or incorrect? I'll give you 15 seconds to ponder over this statement. A money bill passed by the Legislative Assembly cannot be returned by the Legislative Council. What do you think? Money bill once it is passed by both houses of the state legislature, because there are some states which have bicameral legislature, Legislative Assembly as well as Legislative Council. Which are these states which have Legislative Council as well? We have Andhra Pradesh, we have Telangana, we have Maharashtra, we have Bihar, we have Uttar Pradesh, we have Karnataka. These are the only 6 states in India which have a bicameral legislature, which means both legislative assembly as well as a legislative council. There is a controversy regarding legislative council in Andhra Pradesh, because Andhra Pradesh wants to abolish legislative council. What is the process of creating and abolishing a legislative council? Here is a legislative assembly. Let's say this legislative assembly belongs to Jharkhand, where we do not have a legislative council. Legislative Assembly of Jharkhand will pass a resolution by special majority. Basically requesting the parliament that please create or establish a legislative council for Jharkhand. In Jharkhand, we don't have a legislative council. Can Jharkhand have a legislative council? Yes. What is the process? The Legislative Assembly of Jharkhand will pass a resolution. By what type of majority? Special majority. Which type of special majority? More than 2/3 of the members present and voting, plus majority of the total membership of the House. This is the flavor of a special majority. More than 2/3 of the members present and voting and majority of the total membership of the House. Once the Legislative Assembly of Jharkhand passes this resolution is basically requesting the parliament that parliament please create or establish a legislative council for Jharkhand. If parliament wants to create, if parliament accepts this resolution, then parliament will have to pass a law by simple majority. Pass a law by simple majority and legislative council is created. Same is the situation for abolishing as well. If, for example, Andhra Pradesh wants to abolish a legislative council, then Andhra Pradesh Legislative Assembly and Legislative Council, they have to pass a resolution by special majority requesting the parliament that please pass a law by simple majority and abolish the legislative council where it is present. But this resolution passed by the state legislature is not binding on the parliament. Parliament may accept this resolution, parliament may not. And whenever parliament passes a law creating, establishing or abolishing a legislative council, this law, very important statement for your prelims, shall not be deemed as amendment to the Constitution. That means you don't have to use Article 368 to create a legislative council or to abolish a legislative council. It can be done by the parliament by passing an ordinary law, and this ordinary law is to be passed by simple majority. But once this money bill is passed by Legislative Assembly, because money bill can be introduced only in Legislative Assembly. Just like at the central level, money bill can be introduced only in the Lok Sabha. And then it is sent to Legislative Council. What are the options available with Legislative Council? Legislative Council cannot reject a money bill. Legislative Council cannot amend a money bill. Legislative Council may suggest recommendations. And by giving these recommendations, it can return the bill back to Legislative Assembly. Or Legislative Council may pass this money bill. Or Legislative Council may not act on this money bill. And if Legislative Council does not act on this money bill for a period of 14 days, it shall be deemed to have been passed by both houses of the state legislature. Which means this money bill can be returned by the Legislative Council to the Legislative Assembly by providing some of the recommendations. And once this money bill is passed by both houses of the state legislature, it is sent to the governor of that state. This is where you might have a confusion. What are the options available with the governor? Governor is under an obligation that the governor, he or she, cannot do one thing. And what is that one thing that governor cannot do vis-a-vis a money bill? The governor shall not return a money bill for reconsideration. That means governor cannot use suspensive veto when it comes to a money bill. Money bill cannot be sent back by the governor for reconsideration. That's for the governor. But governor can either sign a money bill or withhold his assent to a money bill. The governor can use absolute veto. But normally, the money bill can be introduced in legislative assembly only on the advice of the governor. And since the advice, the recommendation, the consent is given by the governor normally accepts, signs, assents to a money bill. But in some situations, he can also use absolute veto. He may withhold his assent to a money bill. But what governor cannot do, he cannot send the money bill back for reconsideration, which means the governor cannot use suspensive veto. But the Legislative Council can return a money bill back to the Legislative Assembly for reconsideration. So a money bill passed by Legislative Assembly cannot be returned by the Legislative Council. This statement is wrong because it can be returned to the Legislative Assembly with recommendations. If Legislative Assembly accepts these recommendations, the bill is passed. If the Legislative Assembly does not accept these recommendations, even then the bill is passed. Which means when it comes to a money bill, Legislative Council has a very inferior role. Same goes with the Rajya Sabha as well. Rajya Sabha also has a very inferior role when it comes to a money bill. Statement 2, reserving a bill. And please read this statement carefully, because I can sense that some of you are going to make a mistake while answering this question. Reserving a bill for the consideration of the President is one of the discretionary powers of the governor described in the Constitution. When a bill is passed by both houses of the state legislature, then sent to the governor, what are the options available with the governor? Governor can either give his assent to this bill. Governor may withhold his assent to a bill, which means he can use absolute veto. The governor may send the bill back for reconsideration, which means he is using suspensive veto. The governor may not act on this bill at all, may keep the bill lying in his pocket, which is what we call pocket veto. But there is another power available with the governor. What governor can do? Governor can reserve this bill for the consideration of the President. Neat bill, for example, passed by the legislature of Tamil Nadu, sent to the governor for his assent. The governor is not acting on that bill. Some constitutional experts say he should have reserved this bill for the consideration of the President, which he is not doing, or which he was not doing. The point is that the governor has a discretionary power. And this discretionary power is that he can reserve a bill for the consideration of the President. He can reserve any bill for the consideration of the President, including a money bill. So when money bill is something that we discussed, money bill cannot be returned by the governor for reconsideration, but money bill can be reserved by the governor for the consideration of the President. But this is a discretionary power, but this discretionary power is not described in the Constitution. This is not somewhere mentioned in the Constitution. Because what does Constitution say? There shall be Council of Ministers with Chief Minister at its head to aid and advise the governor, who shall act on that advice, except when the governor is to act in his discretion. But what is this discretion exactly is not described in the Constitution, is not defined in the Constitution. But what Constitution does say, in case there is a dispute as to what constitutes the discretionary power of a governor, the word of the governor shall be final. That means governor gets to decide what are my discretionary powers. But there is one obligation here. This is a very important point for your prelims. There is one bill which governor necessarily has to reserve for the consideration of the president. Can you tell me what that bill is? I'm asking that there is one bill which necessarily the governor has to reserve for the consideration of the president. And that bill is, if that bill threatens the power of the High Court concerned. If the Legislative Assembly or if the legislature of a state passes a bill which threatens or takes away the power or the jurisdiction of a High Court, such a bill, the governor will have to necessarily, there is an obligation on the governor that such a bill which threatens the power of the High Court, you have to reserve this bill for the consideration of the president. This is necessary, this is obligatory. After that, beyond that, governor can reserve any bill for the consideration of the president. And this is the discretionary power of the governor. But the only mistake here is that it says this discretionary power is described in the Constitution. Constitution does not describe these discretionary powers. So that makes the statement incorrect as well. Which of the above statements is or are correct? None. Both these statements are incorrect. A money bill passed by the Legislative Assembly can be returned by the Council, and reserving a bill for the consideration of the President is a discretionary power, but it is not described in the Constitution. None of these statements are correct. D is the right answer. Let's look at another question. But before we proceed, let's look at the number of students who are attending this lecture, close to 1.7. And if you're liking this lecture, could you please press the like button so that we can see the level of engagement? Are you sleepy or you're still with me? I try to shout a lot so that I can grab your attention so that you don't feel sleepy. Very nice. According to the Constitution, there shall be a High Court for each state. This statement might be confusing for you. You might get a sense that this statement says there should be one High Court for one state. That means one High Court, one state, one High Court, one state. But we have a system called joint High Courts for some states as well, right? This statement only says every state should have a High Court. That doesn't mean one High Court for one state. It means joint High Court as well. But every state will have to come under the jurisdiction of a High Court. So there shall be a High Court for each state. This statement is correct. High courts and the district courts are treated as the courts of record. What is a courts of record? There are various conditions. I'll tell you two conditions. A court can be a court of record if its orders, if its judgments are recorded for posterity, recorded for a long time, stored, preserved, and these orders or rulings or judgments cannot be questioned before any court of law when they are presented. That is one condition. We say you are a court of record. And second, if you have the power to punish those who commit the contempt of your court. Both district courts, as well as high courts, as well as the Supreme Court, they satisfy criteria 1, which means their orders, their judgments, their rulings, their awards, they are recorded for posterity and they cannot be questioned when they are produced before any other authority. But only the High Court and the Supreme Court has the power to punish people for contempt. And we have seen a lot of contempt of court cases being filed in the Supreme Court recently. Only the high courts and the Supreme Court, they have the power to punish people for contempt. District courts do not have the power to punish people for its contempt or for their contempt. Does that mean you can commit contempt of a district court? No. If you are committing contempt of a district court, then you can be punished for the contempt of court by the High Court. So there is a district court in Tamil Nadu. You are committing contempt of this court. District court cannot punish you. But on the behalf of the district court, the High Court, the Madras High Court, can punish you. That means district courts and high courts, they are treated, that means their orders, judgments, rulings are recorded for posterity, but district courts do not have the power to punish people for contempt. So this statement is incorrect, because only high courts and Supreme Courts, they are treated as courts of record. And one more important thing, it is only in a court of record that a public interest litigation can be filed. Only in a court of record, which means a PIL, a public interest litigation, can be filed only in the High Court or the Supreme Court. Cannot be filed in the district court, because district court is not a court of record, because it does not satisfy criteria 2, because it does not have the power to punish people for contempt. But on behalf of the district court, the High Court of that state can punish you for committing contempt of that court. So statement 2 is incorrect. Which of the above statements is or are correct? A, only one is the right answer. So far as this contempt of court is concerned, contempt of court is both a civil offense as well as a criminal offense. We don't have to go into detail what is a criminal offense, what is a civil offense. But long story short, contempt of court is a civil offense as well as a criminal offense. How can one file a criminal contempt of court case in the court? 3 ways. A, Supreme Court suo motu. Let's say you are committing contempt of a Supreme Court. Supreme Court on its own, suo motu, will take a look at your statements and will punish you for contempt. Or on the basis of the approval or go ahead given by the Attorney General for India. Third, any third person can file a contempt of court case only on the approval of the Attorney General for India. What does that mean? Mr. Kunal Kamra or Mr. Prashant Bhushan, they are alleged to have made some statements or tweeted some information which was viewed as contempt of court. Now, is this statement contempt of court? Can we file a contempt of court case in the Supreme Court? There are 3 ways of doing this. Either Supreme Court on its own, suo motu, will take a look at these statements which are contemptuous and will punish you. Or Attorney General for India will approach the Supreme Court that these individuals have committed contempt of court, please punish them. Or any third person, which means neither the Supreme Court on its own nor the Attorney General for India, but any third person can approach the court asking the Supreme Court that please punish these people because they have committed contempt of court. But this third person cannot file a contempt of court case in the Supreme Court without the approval of the Attorney General for India. If I want to file a case in the court alleging that you have committed contempt of court, I have to first approach the Attorney General, take his permission. Once he gives the permission, only then I can file a contempt of court, a criminal contempt of court case against you in the court. Why is this approval of Attorney General required? We say to save the time of the court. Attorney General's permission is necessary before one can approach the Supreme Court and file a contempt of court case. Why? because this saves a lot of time of the Supreme Court. Once we get the approval, we get the go-ahead from Attorney General, that means the court is now satisfied that yes, this particular case does involve an element of contempt, so we will hear this case. Just to save the time of the court, Attorney General is given this responsibility. Clear? Let's look at another question. While the oath or affirmation of the President is mentioned in the main text of the Constitution, the oath or affirmation of the Prime Minister is mentioned in the third schedule of the Constitution. We are going to have President's election, Vice President's election this year. So you will see 1 or 2 questions asked on these elections in your prelims examination, because UPSC tends to focus on events which come later and preempt those events and ultimately ask questions on these events. Sometimes if there is a big anniversary, 100th year, 125th year, 200th year, there will be a question asked on that particular event. Oath or affirmation, what is the difference between the two? Oath is for believers. Affirmation is for those who do not believe in God, who do not believe or practice a particular religion. For example, I'll take an oath. I swear in the name of God that I will bear true faith and allegiance to the Constitution as per the law established, that I will faithfully discharge the duties of my office. I am taking oath because I'm a believer. If I'm not a believer, I will say, I solemnly affirm that I will bear true faith in the Constitution of the country as per the law established, that I will faithfully discharge the duties of my office. That's the difference. The oath of the President, the oath of the Vice President is mentioned in the main text of the Constitution. But the oath of a minister, oath of a candidate contesting election, oath of the judge of a Supreme Court, oath of the judge of a High Court, oath of, let's say, Comptroller and the Auditor General of India. Where is it mentioned? It is mentioned in the third schedule of the Constitution. But shall I dare tell you something interesting? There is no explicit oath of a Prime Minister. Were you knowing this? There is no specific explicit oath for a Prime Minister. There is no specific oath of a Deputy Prime Minister. They take oath as the Union Ministers. They take oath of office and secrecy as a Union Minister. There is no explicit, direct oath or affirmation of a Prime Minister or a Deputy Prime Minister mentioned anywhere in the Constitution. They take the oath of a minister. So this statement is wrong. There is oath or affirmation mentioned for the President in the main text of the Constitution, but there is no explicit oath of the Prime Minister mentioned in the Constitution or mentioned in the third schedule. Statement number 2. Schedule 6 deals with the administration of the scheduled areas of Assam, Meghalaya, Manipur and Tripura only. What do you think? Is this the right answer? No. Schedule 6 deals with the administration of the scheduled tribal areas in states of Assam, Meghalaya, Mizoram and Tripura. Which of the above statements is or are correct? D. Neither 1 nor 2. D. None of the above is the right answer. Schedule 5 and Schedule 6. There was also a bill in the pipeline which tried to give more power to the autonomous districts in Schedule 6 areas, although that bill hasn't been passed, but can be a potential question for your prelims exam. Schedule 5 deals with the administration of scheduled tribal areas in states other than Assam, Meghalaya, Mizoram and Tripura. In states other than Assam, Meghalaya, Mizoram and Tripura. Because these states are explicitly mentioned in Schedule 6 of the Constitution. those areas or tribal areas which are protected under Schedule 5 of the Constitution, the idea is to protect only the economic interests of tribals. But so far as the tribal areas under Schedule 6 are concerned, the idea is not only to protect their economic interests, the idea is also to protect their social customs, their rituals, their education, their religious features. The idea is to protect their culture as well. Here the idea is to only protect their economic interests. And one important way in which these social, religious customs, practices are preserved, protected, secured is by the creation of autonomous districts. And every autonomous district has a district council. This district council will have 30 members. 26 of these 30 members are directly elected by the people of that district. Remaining 4 are nominated by the governor. And this district council will have the power to impose taxes, will have the power to make laws as well, will have the power to regulate school practices, marriage, divorce, adoption, other areas, other functionalities. Because the purpose of Schedule 6 is to create autonomous districts in these 4 states so as to protect their economic interests, their customs, their rituals as well. And we have 10 such districts in India. We have 3 districts in Assam which come under Schedule 6, 3 districts in Meghalaya which come under Schedule 6, 3 in Mizoram, and 1 district in Tripura which comes under Schedule 6 areas. That means entire Assam is not a Schedule 6 area. Entire Meghalaya, Manipur and Tripura is not a Schedule 6 area. There are 3 districts in Assam which come under Schedule 6. Why this becomes important? Citizenship Amendment Act, which was passed by the Parliament in 2019, under which if you belong to 6 religious minorities coming from 3 countries, Pakistan, Afghanistan and Bangladesh, if you have entered India on or before 31st December 2014, you will not be treated as illegal migrant. And when you are not treated as illegal migrant, which means you are eligible for citizenship. And you will be eligible for citizenship through naturalization. And in fact, the period of naturalization, which originally was 11 years, for these 6 religious minorities, the period of naturalization is slashed from 11 to 5 years. But at the same time, there are some exceptions. That this Citizenship Amendment Act will not apply to Schedule 6 areas. Mr. Amit Shah, who was on a visit as the Home Minister of this country to West Bengal, he promised that we will implement Citizenship Amendment Act after the COVID wave subsides. And one exception of Citizenship Amendment Act is that it does not apply to the Schedule 6 areas of Assam, Meghalaya, Mizoram and Tripura. It also does not apply to areas which are under inner line permit. For example, Arunachal Pradesh, for example, Nagaland, for example, Manipur, because inner line permit was extended to Manipur as well. This can be important statement for your prelims examination. Now let's look at another question. Which of the following is or are part of the concurrent list? All these things have been in the news in the last 1 year. Can be important question for your prelims exam, whether these are part of the concurrent list or state list or union list. Slightly difficult for you to remember, but that doesn't mean you have to memorize all the 97 items which are mentioned in the union list, all the items which are mentioned in the state list, 61 items, all the 47 items which are mentioned in the concurrent list. But just keep a track of the important lists or important subjects which were in the news and just try and find out whether they are part of the union list or state list or concurrent list. Because we will talk about gambling. Don't tell me, sir, you start teaching or you start making a team on Dream 11, we will instead teach Indian polity. I won't do that. But Dream 11, all these fantasy sports, games, there was some controversy in Karnataka, some online betting was banned. Gambling, which is considered to be game of luck. And then we have game of chance. Or should we say the game of skill. Any game involving game of luck is gambling and it is prohibited, except in states such as Sikkim, except in states such as Goa where the casinos are allowed, but game of skill is allowed. And in fact, betting on horse races is allowed. But when it comes to gambling, gambling comes under state list. So gambling is in the news, so you have to be absolutely clear who has the power to make a law on gambling. Is it the power with the center, power with the state, or is it under the concurrent list? It is under the state list. We will also discuss, if not today, then tomorrow, we'll discuss about the Dam Safety Act of 2021, which Tamil Nadu is protesting against. If water is a state list, how can Parliament make a law on Dam Safety Act? Because the dams are created by the states, built by the states, operated by the states, most of them. On water storage, who has the power to make a law? It's a state. So in dams, when the water is stored, how can Parliament make a law? So these subjects which have been in the news, such as gambling, such as water storage, these things which have been in the news, so you have to be sure, absolutely sure, in which of the three lists do they come. Similarly, marriage and divorce, because of increase in the legal minimum age of marriage for girls, this bill is pending inside the Parliament. We saw some laws being passed by UP, Madhya Pradesh, so-called love jihad laws. We have seen triple talaq was declared null and void by the Supreme Court, and then a law was passed by the Parliament called Muslim Women Protection of Rights on Marriage Act. So that relates to divorce, marriage. So these subjects have been in the news. Marriage and divorce is part of concurrent list. Prevention of cruelty to animals in the context of Jallikattu, it's also in concurrent list. Forests, Forest of India report, which is in the news for a long time, it's under concurrent list. Legal and medical professions, because of the controversy surrounding NEET, it's also under concurrent list. Population control and family planning, also in the news, it's also part of concurrent list. So which of the following is or are part of the concurrent list? D, all of the above. But that doesn't mean you have to remember, memorize all these items mentioned in the three lists which come under 7th schedule of the Constitution. Just keep a track of which of these subjects have been in the news and then make up your mind and then look at your notebook, your books to find out whether they are part of the union list or state list or concurrent list. Let's look at another question. Constitution Day is celebrated. Republic Day is also celebrated. And this time we saw Constitution Day was celebrated with much more fanfare. What's the difference between the two? On 26 November 1949, Constitution Day is celebrated. The day when Constitution was adopted. But when it comes to 26th January 1950, this is known as the date on which the Constitution was enacted. And this is what we celebrate as the Republic Day. But do you know, some of you would know, I think most of you would not know, that there are some provisions of the Constitution which came into force, which were enacted on 26 November 1949 itself. That means the entire Constitution did not enter into force on 26 January 1950. Some of the provisions of the Constitution became applicable, became enforceable, were enacted right on this date, 26 November 1949. And all these things were in the news if you have properly read and understood the newspapers. Which are these provisions of the Indian Constitution which came into force on 26 November 1949 itself? Citizenship of those born in the territory of India. It came into force on 26 November 1949. Rights of citizenship of persons who have migrated to India from Pakistan came into force on 26 November itself. In fact, oath of the president. That's why I'm telling you, president becomes a very important topic for your prelims examination because of the presidential election. Even his oath entered into force on 26 November 1949, as well as the Election Commission of India. All these four provisions, Article 324, which deals with the Election Commission of India, where Article 324 says the superintendence, direction, conduct and control of all elections, whether to parliament or state legislatures, whether to president's election or vice president's election, will be vested with a constitutional body called Election Commission of India, which came into force on 26 November 1949. So which of these provisions came into force on 26 November 1949? D. All of the above is the right answer. Let's look at another question. Citizens have the right to an adequate means to livelihood. Means to livelihood. If you look at the unemployment rate, it's been picking up. Unemployment is an issue, was an issue in various state elections as well. Citizens have the right to an adequate means to livelihood, equal pay for equal work for both men as well as women, providing a free legal aid, organization of village panchayats, which comes under Article 40 of the Constitution. Which of the above is or are part of the directive principles of state policy? Directive principles of state policy has always been a favorite of UPSC. And on this DPSPs, we have seen a repetition of the questions as well. So DPSPs, they come under Part 4 of the Constitution, dealing with Articles 36 to 51. Article 36 talks about definition of state. This was in the news where some of the directive principles were sought to be enforced. There was lots and lots of commentary on various directive principles, particularly in the light of COVID-19 pandemic. So DPSP again is a very hot topic, can be relevant and asked in your examination this year. When we look at fundamental rights, Part 3 of the Constitution, the fundamental rights talk about this term called state. There shall be equality before law and equal opportunity, equal protection of the laws. The state shall not deny equality before law and equal protection of the laws. The state shall not discriminate. The state shall not deprive an individual of his right to life and personal liberty. The state shall not do this. The state shall not do that. What is the state against whom the fundamental rights are enforced? If the state violates your fundamental rights, you can drag the state to the Supreme Court. The definition of the state is given under Article 12 of the Constitution when it comes to fundamental rights. Similarly, when we deal with directive principles of state policy, we again come across this term called state. The state shall take steps to organize village panchayats and empower them so that they become units of rural local self-government. The state shall ensure equal work for equal pay. The state shall ensure this. The state shall ensure separation of executive from judiciary. What is the state under Part 4 of the Constitution? It is same as Article 12 of the Constitution. So definition of this term state is same, both for fundamental rights as well as directive principles of state policy. One very important point. But Article 37 of the Constitution, it talks about two important characteristics of directive principles of state policy. Which are these two important characteristics? Number one, DPSPs are not enforceable in a court of law. If your fundamental rights are violated, you can drag the state to the court. But directive principles are not enforceable in a court of law. If these DPSPs are not implemented, you cannot approach the court and ask for the implementation of DPSP. And why are we discussing this? Because of Uniform Civil Code under Article 44 of the Constitution. Various petitions have been filed. Various controversies have been created. Uttarakhand government says, we will implement a Uniform Civil Code in Uttarakhand. There is a Uniform Civil Code already in Goa. So Uniform Civil Code, which is a directive principle of state policy, it is in the news. So everything related to DPSPs you have to understand. But one characteristic of a DPSP under Article 37 of the Constitution is that DPSPs are not enforceable in a court of law. And another important characteristic is, nevertheless, they are fundamental for the governance of the country. So Article 37, it talks about two important characteristics of DPSP. One, they shall not be enforceable in a court of law. But two, nevertheless, they are fundamental for the governance of the country. It shall be the duty of the state to implement these directive principles of state policy. And these directive principles of state policy, the primary objective is to create a welfare state. Fundamental rights under Part 3 of the Constitution, their objective is political democracy. Establishment of political democracy is the objective of fundamental rights, so that there is no distinction between man and a man in a political affair. But so far as DPSPs are concerned, the objective is to promote socio-economic democracy. One more confusion that some of the students have after reading Lakshmikant, they start believing and feeling that DPSPs have been categorized by the Constitution into liberal intellectual principles, Gandhian principles, socialist principles. That's not the case. Article 36 to 51 talks about Part 4 of the Constitution. Article 37 talks about these characteristics. Article 36 talks about the definition of the state. Article 38 to 51 talks about various directive principles of state policy. But nowhere in the Constitution does Constitution categorize these directive principles into Gandhian, socialist or liberal intellectual principles. For our convenience, constitutional experts, they have drawn or they have categorized these DPSPs into various principles, Gandhian, liberal, intellectual and socialist. But this categorization is not done by the Constitution. And these DPSPs, whose primary objective is to establish a welfare state, which are these DPSPs? Which of the above is or are part of the directive principles of state policy? All of them is the right answer. Because all these points, statements 1, 2, 3 and 4, these are directive principles mentioned under Part 4 of the Constitution. Does that mean, sir, we have to remember and memorize all these directive principles? Take a look at all these directive principles, read them multiple times, you will remember it at the time of the examination. It is sometimes necessary to remember all these DPSPs, just like it is important to remember all the fundamental duties. Clear? For fundamental duties, for example, I normally tell my students a trick as to how to remember these fundamental duties. For example, I tell them a story. The story is that you want to become an IPS officer. And as an IPS officer, you are appointed as the SSP, Senior Superintendent of Police. But you are also a very corrupt one. Suddenly there is a knock at your door and there are people from anti-corruption unit knocking at your door and they're asking you, let's go to the jail. You're asking the anti-corruption unit officers, why? Because they say you are under arrest because you have indulged in corruption. Now you are saying, where is the proof? And they show you a DVD where it is shown that you are taking or giving bribes. Ultimately, what will you do? You will start a PR exercise, public relations exercise. Basically, call your friends in media, journalists, that please don't publish this news, don't broadcast this news. The nation doesn't want to know that I'm being arrested. And ultimately, this PR exercise will lead to your victory. 3, 6, 9, 10, 11. These are the 11 fundamental duties mentioned in the Constitution. To strive towards excellence in all areas of human endeavor, to safeguard public property and abjure violence, to protect and promote the natural environment, wildlife, forests, to abide by the Constitution, respects its ideals, national flag and the national anthem, to cherish and follow the rich heritage of our composite culture, to uphold the unity, integrity and sovereignty of the nation, to develop scientific temper, humanism and spirit of reform, to value and preserve the rich heritage of our composite culture, to defend the country and render national service when called upon to do so, to promote a sense of brotherhood, harmony amongst different sections of the society and renounce the practices which are derogatory for the dignity of the woman. And whoever is the guardian or parent of a child or a ward in the age group of 6 to 14, there is a fundamental duty imposed on you that you have to provide educational opportunities to these children in the age group of 6 to 14. And these are the 11 fundamental duties mentioned in the Constitution. And these DPSPs or these fundamental duties, they were not originally part of the Constitution. They were added to the Constitution by 42nd Constitutional Amendment Act 1976. And these fundamental duties were added based on Sardar Swaran Singh Committee. These fundamental duties are under Part 4 capital A of the Constitution. It deals with Article 51 capital A. Originally, there were 10 fundamental duties added by 42nd Amendment. The 11th fundamental duty was added by 86th Constitutional Amendment Act 2002, which is related to education. Because 86th Constitutional Amendment Act, it also spoke of fundamental right to free and compulsory primary education to all the children in the age group of 6 to 14. It was in that constitutional amendment that this fundamental duty was also added. And there is a context to fundamental duty chapter as well. Prime Minister Modi, Honorable Prime Minister, recently also said that we have been for long focusing on rights, we should have more attention paid to duties as well. In fact, some of the judges of the Supreme Court also said the same thing. In fact, this is the same thing what Srimati Indira Gandhi said when Constitution was amended in 1976. She was asked, what is the need to have fundamental duties? Chapter mentioned in the Constitution. She said, people are aware of their rights. I want to make them aware of their duties. And these fundamental duties are exclusively available to citizens. But one more important thing, these fundamental duties, there can be no mandamus. What does it mean, no mandamus? Under Article 32 of the Constitution, if a public authority is not performing its duty, what you can do, you can approach the Supreme Court and ask Supreme Court for a writ of mandamus. Because somebody, a public authority, is not doing its duty. But this duty is not same as that of a fundamental duty. So if you and me are violating fundamental duties, are not following the fundamental duties, you cannot approach the court, ask the court for the issuance of a writ of mandamus and force me to do this duty. Because these duties are not legal duties. Violation of legal duties can lead to the invocation of mandamus, but not fundamental duties. Clear? That is related to fundamental duties. Okay. Which of the following statements regarding the one nation, one ration card is or are correct? Let's look at this topic. Very, very important, can be asked in your examination. We have National Food Security Act of 2013, under which subsidized food is provided to the beneficiaries, provided to the weaker sections of the society. Subsidized food such as rupees 3 per kg for rice, rupees 2 per kg for wheat, rupee 1 per kg for various grains. And if you belong to the selected group of beneficiaries under National Food Security Act of 2013, you can get all these subsidized food items at any fair price shop in India. But now, because of COVID-19, when there was a migration of the people as well, if I am registered as a beneficiary in West Bengal, I cannot get the benefit of this National Food Security Act in Delhi or in Mumbai or in other parts of the country. This is where, on the directions of the Honorable Supreme Court, a very important reform was sought to be implemented known as One Nation, One Ration Card. That means you can get the subsidized food items. Even if you are a beneficiary in one state, in any other state, you can get this benefit. You can get the subsidized food. That's called One Nation, One Ration Card. And for that, some technological solutions were to be provided. Technological solutions such as EPOS, electronic point of sale machine. If I am a beneficiary, I will go to a fair price shop where they will have this electronic POS machine. I will provide my Aadhaar. I will also provide my ration card. By providing my Aadhaar, by providing my ration card, the fair price shop individual will authenticate my identity. Will basically say whether you are eligible for these subsidized food grains or not. Clear? But now biggest reform is that this EPOS would be linked with two databases. One is Integrated Management Public Distribution System database. The other is Anna Vitran portal. The whole purpose of this One Nation, One Ration Card is, if I am a migrant, not just me, even my family members, using this ration card and the Aadhaar, they can get subsidized food grains in all the fair price shops anywhere in the country. But we need to keep track of these transactions as well. We need to keep track of these benefits as well. That is why technology comes into picture and these two portals are to be maintained. Integrated Management Public Distribution System portal will keep note of the transactions which are interstate. Beneficiary from West Bengal, I am getting the benefit from Tamil Nadu. Database called Integrated Management Public Distribution System will keep track of all these interstate transactions. This Anna Vitran portal will keep the track of intrastate, or should we say inter-district. I am part of District A, beneficiary listed in District A, but I am getting the benefits from a District B. This Anna Vitran portal will keep track of these transactions inter-district or intrastate. This is One Nation, One Ration Card on the directions of the Honorable Supreme Court. Let's look at the question. The question is, the One Nation, One Ration Card, which of the following statements regarding One Nation, One Ration Card is or are correct? The One Nation, One Ration Card scheme is aimed at enabling only the migrant workers and not their family members to buy subsidized ration from any fair price shop anywhere in the country under the National Food Security Act 2013. This allows migrant as well as his family member to get the benefit under National Food Security Act. So this statement is wrong. The center has set the implementation of One Nation, One Ration Card as a precondition for additional borrowing by the states. If the states wants to borrow more additionally over the top, one requirement is, one precondition is, one prerequisite is that they should have implemented this One Nation, One Ration Card scheme. So this statement is correct. Non-National Food Security Act ration card holders, which means the ration cards issued by the state government, they are also covered under One Nation, One Ration Card. No. In fact, some states such as West Bengal, Delhi, they did not implement One Nation, One Ration Card scheme for a long time. West Bengal was basically protesting, saying the ration cards issued by us, by the state government, they should also come under One Nation, One Ration Card. But the central government said no, only the ration cards issued by the center will be eligible for this One Nation, One Ration Card scheme. So 1 and 3 are incorrect. The question is asking which of the following is correct. B, only 2 is the right answer. Let's look at another thing. With respect to the functioning of the parliament, consider the following statements. Number 1, the presiding officer of both the houses can order the removal of a misbehaving member in their respective houses. Who is the presiding officer? In Lok Sabha, it is the Speaker. In the Rajya Sabha, it is the chairperson of Rajya Sabha or the Vice President of India. Whenever a member is misbehaving, and what is misbehavior? Somebody entering the well of the house, somebody tearing a bill copy, somebody throwing a microphone, somebody using sloganeering, somebody is displaying a placard or a poster. All this comes under misbehavior. And what the presiding officer can do, if you have followed the parliamentary proceedings, you would also have noticed that sometimes presiding officer, they threaten the MPs. Don't do this, otherwise I will have to name you. I will name you, sit down, I will name you. Whenever the presiding officer names a member who is misbehaving, marshals will come and will whisk those misbehaving MPs outside. Ordering the removal of these misbehaving MPs is the right, is the duty, is the job, is the power of a presiding officer, both in Lok Sabha as well as in Rajya Sabha. So the presiding officer of both the houses can order the removal of a misbehaving member in their respective houses. This statement is correct. Both speaker and chairman can suspend a member in their respective house. This statement is wrong. You are ordering the removal of a misbehaving MP. But this MP can later come back as well. But who has the power to suspend an MP? I am suspending you. You cannot come to the parliament again for today. Or you cannot come for the remainder of the session. For the entire monsoon session, don't you dare enter the parliament. This power to suspend an MP is with the speaker. Speaker can suspend an MP. But this power is not given to the chairman. But then how are the MPs in Rajya Sabha suspended? MPs in Lok Sabha are suspended by the speaker. MPs in Rajya Sabha are suspended by the resolution passed by the Rajya Sabha. So Rajya Sabha MPs, they will have to pass a resolution by simple majority, and then MPs will be suspended. And this was the controversy when last few years some MPs have been suspended from Rajya Sabha, and voting has taken place through voice vote. Through voice vote, Rajya Sabha MPs have decided to suspend some of their colleagues. But this power is with the Speaker of Lok Sabha to suspend an MP, but this power is with the House of Rajya Sabha, not with the Chairman of Rajya Sabha when it comes to Rajya Sabha. So statement 2 is incorrect. A member of the House can't be suspended for a period exceeding the remainder of the session. This is correct. If I'm a misbehaving MP, I can be suspended from the parliament, but for a maximum period of the remainder of the session. Which means if this is budget session continues for another 10 days, maximum I can be suspended is for these 10-day period. After that, in the next session, I will have to come back to the parliament. With respect to the functioning of the parliament, consider these statements. Which of the above statements are correct? 1 and 3 are correct. So C is the right answer. Sometimes, and this is where some of the students, they make mistake. And the mistake is, what if it is asked, which of the following statements are incorrect? What is the answer? The answer is only 2. Then this becomes the answer. But while you are marking your OMR sheet, and once you come back home, you say, oh, the question was asking for incorrect. I marked which of the above statements are correct. So I made the wrong choice. So first you have to read it carefully whether the question is asking for which of the following statements are correct or incorrect. And to make it even better, with respect to these statements, just say this statement is correct, this is incorrect, this statement is correct. So that once you use these letters C, I, C, C is correct, I is incorrect. So then you say which of the following statements are correct. Correct is 3 and 1. So this is the right answer. Which of the following is incorrect? You just have to look at which of the following is incorrect. So it is only B. This way, if there are multiple statements given in your question, always do one thing. 1, write it as I as incorrect, C as correct. At the same time, do thing number 2. Check what is the question asking. Is the question asking for you to pick the correct answer or pick the incorrect statements? Third, sometimes there are aspirants who take a look at the question paper. Then in the question paper itself, they mark the answer. So for question number 1, the answer is A. Question number B, the answer is B. Question number 10, the answer is C. And then at the end, they fill the OMR sheet. Don't make this mistake. Because if you made any mistake on the OMR sheet, you will not be given another OMR sheet. Clear? So what some people do, they attempted the first 10 questions, but then they could not attempt question 11, question 12. So they leave it blank. But then when they look at question number 13, 14, 15, they have marked they know what is the correct answer. But while filling the OMR sheet, they become confused and they start even marking 11th and 12th as the answer to 11, 13 and 14. So, and then they realize, oh, I should have left these questions blank because I don't know the answer to these questions. And then the entire OMR sheet is a waste. And this is something which a very, very good, promising student of ours faced in the last prelims examination. Otherwise, in my sense, he should have been a topper. But he couldn't clear the prelims exam because he made this mistake. So please don't make this mistake. 1, read the question properly. as to what the question is asking. Is the question asking you to pick the correct answer or incorrect answer? Sometimes you make these mistakes. That is why mention in the statement C as correct, I as incorrect. And the moment you answer a question, you know the answer to this question, immediately fill the OMR sheet. Clear? Don't leave it towards the end, because then you are going to lose a lot. Clear? So let's continue. Which of the following statements is or are correct? And this is in the backdrop of what happened in Uttarakhand. Mr. Tirath Singh Rawat, who was the member of the Lok Sabha, without resigning from Lok Sabha, he continued as the Chief Minister of Uttarakhand. And after that, he was asked to resign as the Chief Minister of Uttarakhand, and then he came back to Lok Sabha. Is it possible? Is it valid? Is it constitutional? Let's look at the question. It is constitutional. In a sense, Mr. Rawat made no mistake while continuing as the member of the Parliament of Lok Sabha as well as the Chief Minister of Uttarakhand. Because you are a Chief Minister of Uttarakhand, but you are not a member of Legislature of Uttarakhand. You can be appointed as a Chief Minister, as a Minister, but within 6 months you have to get yourself elected to the Legislative Assembly. So for 6 months, Mr. Rawat could have continued as the member of the Lok Sabha as well as the Chief Minister. But then once you contest the state election, you have to give up the Lok Sabha seat. Clear? If a person is elected to both the houses of the Parliament, he or she must intimate within 10 days in which house he or she desires to serve. Else, her seat in Rajya Sabha becomes vacant. If a person is elected to both houses of the Parliament, Lok Sabha as well as Rajya Sabha at the same time, can he continue? No. In both the seats, no, because there is no such thing as dual membership. In fact, when a person is elected to Legislative Assembly as well as elected to, let's say, Lok Sabha, a Lok Sabha MP is elected to the Legislative Assembly, as soon as possible after the election, he has to communicate as to which house he wants to serve. This is what happened with Akhilesh Yadav. He was a member of the Lok Sabha, he got elected to Legislative Assembly as well, resigned as the member of the Lok Sabha, continues as the member of the Legislative Assembly from the Mainpuri constituency, I think in UP, where he is now the leader of the opposition. So if a person is elected to both the House of the Parliament, he must intimate within 10 days in which house he desires to serve, else his seat in Rajya Sabha becomes vacant. The statement is correct. C. If a sitting member of one house is also elected to the other house, he must intimate within 6 months which house he desires to serve, else his seat in the first house becomes vacant. This is incorrect. If a sitting member of one house is elected to the other house, his seat in the first house automatically falls vacant. If I am elected to Lok Sabha currently, I am a Lok Sabha MP, now I have got elected, after a few months, I have got elected to Rajya Sabha as well. Automatically, my seat in Lok Sabha falls vacant. That means this is incorrect. A person elected to both the Parliament and the state legislature must intimate within 14 days in which house he desires to serve, else his seat in the Parliament becomes vacant. This is correct. That's what Mr. Akhilesh Yadav did. So the question is asking which of the following statements are correct. Correct is 1 and 3. 1 and 3. B is the right answer because statement 2 is incorrect. This brings us to the closure of today's session. We have discussed lots of issues, lots of concepts, very important concepts as well regarding Indian polity. We'll meet one last time tomorrow, 7:30 p.m. We'll continue till 9:30 p.m. and discuss the fourth and the most interesting, most exciting, most promising session of the Target Prelims 2022 crash course. See you tomorrow, 7:30 p.m. in the evening. But before you end this lecture, please press the like button, comment once the video is over. Today, I'll promise I'll go through all your comments one by one and possibly reply to them as well. And don't forget to press the subscribe button so that you never miss any update. Thank you so much for being part of us, for being part of this beautiful journey. I'll see you tomorrow, 7:30 p.m. Till then, have a great time. Good evening.